Welcome to Prevention Link's presentation on the duty to accommodate. This workshop focuses on the most frequently cited ground of discrimination, that is disability. It looks at how disability and the duty to accommodate plays out with particular emphasis on employment. The Canadian Charter of Rights and Freedoms protects a number of rights and freedoms, including freedom of expression and the right to equality. It forms part of our Constitution, the highest law in all of Canada, and is one of our country's greatest accomplishments. The Charter came into effect on April 17, 1982. Section 15 of the Charter, Equality Rights, came into force 3 years after the Charter, so that governments had time to ensure their laws and policies respected everyone's equality rights. Human rights, described as all the things we are entitled to be, to do, or to have simply because we are human. How we instinctively expect to be treated as persons. We are all entitled to a life of equality, dignity, and respect. You do not have to earn your human rights, you are born with them. It's the same for every man, woman, and child on earth. Nobody can give them to you, but they can be taken away. In Canada, human rights are protected by federal, provincial, and territorial laws. Canada's Constitution splits legal responsibility or jurisdiction between the federal and the provincial or territorial governments. In Ontario, we have the Ontario Human Rights Code and the Canadian Human Rights Act. Not all provinces and territories in Canada offer the same human rights protections. For example, not all provinces protect people because of their political beliefs. Human rights are not optional. The Ontario Human Rights Code is for everyone. It's a provincial law that gives everybody equal rights and opportunities without discrimination. The Canadian Human Rights Act protects people in Canada from discrimination when they are employed by or receive services from the federal government, First Nations governments, or private companies that are regulated by the federal government, such as banks, trucking companies, broadcasters, and telecommunications companies. Both have primacy and prevail over all other laws. Human rights legislation is interpreted broadly and liberally to achieve purpose. It's remedial and not punitive, and considers effect, not intent. It doesn't matter how the legislation is specifically worded or interpreted, it matters only that discrimination is prevented. You cannot challenge by way of technicality. It's intended to look for remedy rather than just punishing. For example, the Highway Traffic Act is an example of punitive legislation. If you speed, you get punished. The remedy is to remove the discrimination, however, there could be punitive damages ordered. It does not matter whether a rule or practice was intended to apply equally or fairly to everyone. It focuses on the effect and not the intent. There are many protected grounds listed in both the Ontario Human Rights Code and the Canadian Human Rights Act, such as age, ancestry, color, race, citizenship, and so on. But today we will focus on disability, the protected ground of disability. We will focus on the social area of employment and the protected ground of disability under the Ontario Human Rights Commission. The goal and purpose of accommodation is to ensure that a worker who is able to work can do so. In practice, this means that the employer must accommodate the worker in a way that, while not causing the employer undue hardship, will ensure that the employee can work. The purpose of the duty to accommodate is to ensure that persons who are otherwise fit to work are not unfairly excluded where working conditions can be adjusted without undue hardship. The duty to accommodate has both a substantive and procedural component. An organization will not be able to argue persuasively that providing accommodation would cause undue hardship if it has not taken steps to explore accommodation solutions. The procedural aspect, meaning the process, involves the considerations, assessments, and steps taken to respond to an accommodation need. This includes an individualized investigation of potential accommodation measures to address those needs. The substantive duty is about the appropriateness or reasonableness of the chosen accommodation, as well as the reasons for not providing an accommodation, including proof of undue hardship. The three principles of accommodation are 1. Respect for dignity, 2. Individualization, and 3. Integration and full participation. Accommodation must be provided in the way that most respects the dignity of the person, if doing so does not cause undue hardship. Human dignity encompasses individual self-respect, self-worth, and inherent worth as a human being. This includes being considered as a whole person, not merely in relation to one's disability. There is no set formula for accommodating people. Each person's needs are unique and must be considered afresh when an accommodation request is made. People sharing the same condition often experience it in very different ways, with different symptoms, limitations, and prognosis. In terms of accommodation, what might work for one person may not work for another. Accommodations may need to be revisited over time to make sure that they continue to meet the person's needs appropriately. Achieving integration and full participation requires barrier-free and inclusive design, as well as removing existing barriers. Where barriers continue to exist because it's impossible to remove them, then accommodations should be provided up to the point of undue hardship. In employment, essential duties are the vital or indispensable aspects of someone's job. A worker cannot be judged incapable of performing the essential duties of a job unless it can be shown that the person's needs cannot be accommodated without undue hardship. An organization should not conclude that a person is unable to perform the essential duties without actually giving the person an opportunity to demonstrate their ability. In these cases, a next best solution, such as alternative work, may need to be found. There is a duty to accommodate a person in their pre-disability job wherever possible. However, it's recognized that this may not always be feasible. Human rights case law recognizes that employers have a duty to consider temporary and permanent alternate work for people who can no longer remain in their position, even with accommodation. Human rights case law recognizes that employers have a duty to consider temporary and permanent alternative work for people who can no longer remain in their position. This duty includes diligently investigating positions and proposing job options that are within the person's functional limitations. Both employers and unions must cooperate in accommodating employees who are returning to work. Accommodation is a fundamental and integral part of the right to equal treatment in the return to work. The Code prescribes only 3 considerations when assessing whether an accommodation would cause undue hardship: cost, outside sources of funding, health and safety requirements. No other consideration can be properly taken into account under Ontario law. Therefore, factors such as business inconvenience, employee morale, and customer and third-party preferences are not valid considerations. To claim the undue hardship defense, the organization responsible for making the accommodation has the onus of proof. It is not up to the person with a disability to prove that an accommodation can be accomplished without undue hardship. The nature of the evidence required to prove undue hardship must be objective, real, direct, and in the case of cost, quantifiable. The organization responsible for the accommodation must prove facts, figures, and scientific data or opinion to support a claim that the proposed accommodation in fact causes undue hardship. A mere statement without supporting evidence that the cost is too high or inconvenient based on speculation or stereotypes will not be sufficient. It is important to note that the duty to accommodate is a shared responsibility. The person with the disability is required to make accommodation needs known to the best of their ability, preferably in writing, provide information about relevant restrictions and/or limitations, take part in discussions about possible accommodation, cooperate with any experts whose assistance is required to manage the accommodation process or when information is needed that is unavailable to the person with a disability. Meet agreed upon performance standards and requirements such as job standards once accommodation is provided, and work with the accommodation provider on an ongoing basis to manage the accommodation process. The accommodation provider is required to be alert to the possibility that a person may need an accommodation even if they have not made a formal request, accept the person's request for accommodation in good faith unless there are legitimate reasons for acting otherwise, get expert opinion or advice where needed, but not as a routine matter, take an active role in ensuring that all alternate approaches and possible accommodation solutions are investigated, keep a record of the accommodation request and action taken, and communicate regularly and effectively with the person. The accommodation provider is also required to maintain confidentiality, limit requests for information to those reasonably related to the nature of the limitation or restriction to be able to respond to the accommodation request, consult with the person to determine the most appropriate accommodation, implement accommodations in a timely way, bear the cost of any required medical information or documentation. For example, the accommodation provider should pay for doctor notes, assessments, letters setting out accommodation needs, etc., and also bear the cost of the accommodation. The type of information that accommodation seekers may generally be expected to provide includes that the person has a disability, the limitations or needs associated with the disability, whether the person can perform the essential duties or requirements of the job with or without accommodation, the type of accommodation that may be needed to allow the person to fulfill the essential duties or requirements of the job, and regular updates about when the person expects to come back to work. Documentation supporting the need for a particular accommodation should be provided only to the people who need to be aware of the information. For example, it may be preferable in some circumstances for information to be provided to the company's health department or human resources staff rather than directly to a supervisor to further protect confidentiality. Accommodation and COVID-19. The Ontario Human Rights Commission's policy position is that the Code ground of disability is engaged in relation to COVID-19, as it covers medical conditions or perceived medical conditions that carry significant social stigma. Employers have a duty to accommodate employees under the Code in relation to COVID-19 unless it would amount to undue hardship based on cost or health and safety. An employer must accommodate an employee who has caregiving responsibilities up to the point of undue hardship. These caregiving responsibilities, which relate to Code ground of family status, could include situations where other family member is ill or in self-isolation, or where their child's school is closed due to COVID-19. Potential accommodations can include allowing employees to work from home where feasible, permitting employees to work alternate hours, allowing employees to take leaves from work, or other flexible options. On March 19, 2020, Ontario passed Bill 186, Employment Standards Amendment Act, Infectious Disease Emergencies 2020, which provides that an employee will not be required to provide a medical note if they need to take a leave related to COVID-19. Unions not only have a moral obligation, but also bear a legal responsibility when it comes to accommodating persons with disabilities. In employment, unions and professional associations are required to take an active role as partners in the accommodation process, share joint responsibility with the employer to facilitate accommodation, and support accommodation measures regardless of collective agreements, unless to do so would create undue hardship. The union would also be held liable if it prevents or impedes the employer in accommodating a worker. The courts recognize the union does have an obligation to represent the interests of the other workers in the bargaining unit. Collective agreements or other contractual arrangements cannot act as a bar to providing accommodation. Policy on ableism and discrimination based on disability. This is the Ontario Human Rights Commission's interpretation of the Code and sets out standards, guidelines, and examples. It's intended to provide clear, user-friendly guidance on how to assess, handle, and resolve human rights matters related to disability. The document itself is dated June 27, 2016. All of society benefits when people with disabilities are encouraged and empowered to take part at all levels. This policy will help organizations understand their rights and obligations under the Code, design their facilities, policies, and procedures inclusively, respond to accommodation requests, address complaints related to disability, and find further resources. The policy can be found on the Ontario Human Rights Commission website or by just searching the title of the policy in Google. Prevention Link has 3 distinct pillars, the first being Occupational Disability Response Training, which is multi-day courses that introduce, educate, and enable participants to become confident and knowledgeable in a range of topics essential to workers' compensation and disability accommodation. Secondly, the Lighthouse Initiative is designed with vulnerable and marginalized workers in mind. The aim of the initiative is to provide easily accessible and reliable information on occupational health and safety, employment standards, human rights, and workers' compensation. And thirdly, the Return to Work consulting branch of Prevention Link facilitates a strategic fit with workplace return to work best practices. We envision a province where occupational illnesses and injuries are eliminated to enable healthy, safe, and accommodating workplaces for all workers in every workplace in every community across Ontario. Thank you.